sir, for the appellant.
Yes, Your Honor. My name is Gerald Gully of the Knoxville Bar. I am here on behalf of the appellant, Zora Humphrey, in this appeal from the Knox County Chancery Court. I request that the court reserve 5 minutes for rebuttal. Thank you, Your Honor.
Thank you.
Your Honors, this case arises out of a conservatorship proceeding in the Chancery Court for Knox County. Mr. Hall, on behalf of the UT Hospital, filed a petition for conservatorship against Ms. Humphrey. I believe in February of 2022, a guardian ad litem, Carolyn Gilliam, was appointed based on her interview with Ms. Humphrey. She requested that the court appoint an attorney ad litem because Ms. Humphrey wished to contest the conservatorship. Pursuant to court order, I believe March 2nd of 2022, I was appointed as the attorney ad litem for Zora Humphrey to represent her in the contest of the conservatorship. On March 7th, less than a week after the order appointing me, I filed an answer on behalf of Ms. Humphrey and contemporaneously filed an objection to the use of the affidavit of Dr. Taylor Wright, whose affidavit was attached to the petition, objecting to the use of that as substantive evidence of disability on the grounds that it constituted impermissible testimonial hearsay and denied Ms. Humphrey her right to confront Dr. Wright as provided in Tennessee Code Section Annotated 34-3-106 Subpart 2, which specifically provides that respondents in conservatorship proceedings have the right, among other things, to confront the witnesses against them. Trial was held on March 16th, 2 weeks after the order appointing me as attorney ad litem. The day before that, on March 15th, Ms. Gilliam, the guardian ad litem, filed her report. And at trial the next day, Ms. Humphrey appeared by Zoom. And I again raised the objection to the use of the affidavit of the physician because...
Excuse me for interrupting.
Yes, Your Honor.
Counsel, was there a written motion filed in advance of the hearing objecting to the report and the affidavit being considered as substantive evidence? Yes,
Your Honor. There was a document-styled objection. It was filed the same day that I filed the answer. And it is in the record, but there was, within the answer itself, I did file, and that's in the supplement, volume 2, I did file an objection to the use of the affidavit, but I also filed a separate document, which is it's in the record, a separate document objecting to that use. So on 2, and it is in the record, I don't have the page, but it was filed March 7th, styled objection by respondent by and through attorney ad litem to affidavit of physician dated February, so forth.
And that objection was ruled upon during the hearing?
It was ruled upon, I guess, at the beginning of the hearing. I asked, there was not going to be a live witness, or the doctor was not going to appear. There was no deposition noticed of him, and he was otherwise not going to appear. I raised that issue, and I believe the court's order on page 42 of the record reflects that that issue was brought to the court's attention yet again, orally. And the court denied that motion as well as, I guess, the underlying objection and the statement in the answer. So the court was well aware of it, of our position, and the court specifically refused to that objection.
In reviewing the briefs, it's also my understanding that there was a request or a motion for a continuance?
Yes, Your Honor. At that time, once the court ruled upon or denied my motion to exclude the affidavit of Dr. Wright, at that time I moved for a continuance so that either a deposition of Dr. Wright could be taken or that the respondent would have the opportunity to go out and seek medical testimony on her own behalf, which she is allowed to do under 34.3.105, I believe, subpart B. The court denied that motion for continuance also, even though there was no real legal prejudice. I would suggest to the court no real legal prejudice to the petitioner for doing so.
Did the trial court elucidate the basis or the reasoning for denying the motion for continuance?
No, Your Honor.
Likewise, did the trial court explain why it overruled the motion or denied the motion, objecting to the consideration of the affidavit as substantive evidence?
No, Your Honor. My recollection, and I'm loath to state it since I don't think it's expressly in the statement of facts, but my sense was that the court made comments to the effect that we need to get on with this. But again, there is nothing specifically in the statement of facts that was submitted as part of the record that I think identifies that. So just...
Mr. Gully, is the affidavit the same thing as the sworn medical report under 34.3.105D?
Yes, Your Honor.
Okay, so we know that that is allowed to be presented as prima facie evidence of disability.
Under certain circumstances, I think the language in 34.3.105D says that it may be considered as prima facie evidence if not contested and found to be valid. Or I'm sort of paraphrasing. So if there is no objection to it, then it may be considered.
And you objected.
Or if there is an objection and the trial court finds that there is a valid basis for it, then it may be considered as prima facie evidence. Otherwise, if it is objected to or contested, then basically you have to get on to a contested evidentiary hearing, which means the petitioner has to come forward because they have the affirmative duty to present, testimony about disability. So, at any rate, after the request to not allow the affidavit to be used was denied by the trial judge, after the oral motion for continuance was denied by the trial judge, there was a hearing. There were two live witnesses. There was Ms. Gilliam, the guardian ad litem, who testified briefly. Basically, she said that when she went to visit Ms. Zora Humphrey at UT Hospital, Ms. Humphrey made some comment about some sort of optical hallucination, that a figure in a poster was going to come out and harm her. Ms. Gilliam also stated that she did not know whether Ms. Humphrey was under any medications at the time that could have produced or have caused that optical hallucination, nor did Ms. Gilliam go back and speak again with Ms. Humphrey to determine whether there was, this was sort of an ongoing condition or if it was sort of, a one-off. Ms. Humphrey testified by Zoom. She testified that she did not want a conservator, that she was able to handle her own affairs, and that she wanted the petition to be denied. So based on the improper consideration, we respectfully suggest, of the affidavit of Dr. Wright that was part of the petition, and after the two brief live witnesses, the court found by clear and convincing evidence that Ms. Humphrey was disabled and needed a conservator for both person and property. We have set forth in our brief, Your Honor, the basis for the issue regarding the statutory construction, and that the fact that the trial court, it was improper for the trial court to deny my client the opportunity to confront the medical witnesses against her, and that is very clear by analogy with criminal proceedings. Crawford versus Washington, the United States Supreme Court, the U.S. Supreme Court in that case, albeit a criminal case, said basically that there was such a concern, such a fundamental liberty interest at stake, that use of testimonial hearsay should not be allowed. There has to be confrontation in the crucible of cross-examination to determine where the truth lies. And that is what was denied my client in this case, Your Honor. I respectfully suggest also that the testimony of the guardian ad litem was insufficient. I see that my time has concluded, Your Honor, so at this point I will turn it over to Mr. Reeves, Your Honor.
Thank you.
Good afternoon. I'm Bill Reeves of the Knoxville Bar, here on behalf of the conservator, which was appointed as a result of the hearing that's just been described. So the conservator was not a party to the hearing. The hearing was by Zoom, and as normally happens, the conservator and I both heard the hearing, but we were not parties. The conservator, as the public guardian, does not believe it's appropriate for the conservator, and also because we're the conservator of the respondent, to take a position on this issue about the conflict, apparent conflict in the statutes. All we care about, frankly, is her best interest. And for that reason, in our brief, we requested that the court not dismiss this case if, in fact, you find that there was reversible error committed by the admission of the sworn statement, that you remand it for further disposition by the trial court, not attempting to go outside the record, but we attempted to tell the court our current position about Ms. Humphrey or her current condition. I understand why you excluded that, but it seems to me, and this is perhaps more personal than part of the record, there is an issue here. It is confusing to trial courts and to counsel about this statutory contradiction. And I recall, I think in 2013, when the statute was amended to provide for the prima facie quality of the sworn medical statement, it was to address the same problem, but it did not amend or address the section about the right to cross-examine. So you still have a lack of clarity, I think, between those two statutes. So having said that, I will yield the rest of my time if Mr. Gully needs it.
Won't yield it to him. We won't let you do that.
I'll request that the court allow the time to be, if it's within the discretion of the court and the court's wishes.
No. I think we'll let it go with him having his full time, and that's it.
What lawyer can turn down the opportunity to talk, Your Honor?
They're really good ones, Mr. Gully.
Oh, well, thank you, Your Honor. And I thank Mr. Reeves. Mr. Reeves has stated that, and I think I requested 5 minutes originally. Mr. Reeves stated that there is some sort of contradiction between the language in 34.3105D about the prima facie evidence and 34.3106 subpart 2 or 105, regarding confronting witnesses. And I respectfully suggest that there is no conflict between this statute if this court determines, as we had suggested in the brief, that, and which basically the language in 34.3105D, I think, states that the medical affidavit can be used as substantive evidence, as prima facie evidence, unless it is contradicted, unless it is contested and found not to be valid. That's what we did here. We stated in the answer, we objected to it. We filed a separate document objecting to it. We're contesting it. I mean, it's pretty obvious. That's what we're doing. And we didn't get the chance to confront the witness by cross-examination and use that truth-telling function of the court to determine whether it would be valid. But there is no inherent or necessary conflict between the two statutes, between the two statutory sections. Once an objection or once a contest is given notice, by the respondent.
Mr. Gully, do you agree with Mr. Reeves that if we find that the case does need to be remanded, that for Ms. Humphreys, the status quo should remain in terms of her current care and placement, or should we go back to as if she has no conservatorship?
Your Honor, I think that based on what's in the record and the documents that Mr. Reeves referred to were upon motion stricken, and there is nothing in the record relating to the current competency or disability of Ms. Humphrey, then I think the court, because of the, I don't want to say constitutional error, but the error affecting the constitutional rights of Ms. Humphrey to confront the witnesses against her in this proceeding to strip her of her liberty interests, I think that the court would be compelled on the record before it to dismiss the conservatorship. That doesn't prohibit someone else, a person with knowledge, from coming back and filing another petition. And that's all that it requires is a person with knowledge about the condition, of someone. Someone at the facility that she's at, could do that. Ms. Gilliam could do that. I understand from Mr. Reeves that Ethra would be prohibited from doing that by statute, but it would not prohibit another individual from asking the court below to revisit that. But I think this court, based on the record before it, would be compelled to dismiss as opposed to remand, Your Honor. Your Honor, if I can just wax philosophical for a moment. Mr. Reeves and I do a lot of work in conservatorships here in Knox County and elsewhere. We see these cases day in and day out, and Mr. Reeves certainly, from his vantage point as a counsel for East Tennessee Human Resource Agency, sees a lot of these cases. I am reminded of the words of Dwight Eisenhower when he gave his farewell address in 1961, and he spoke about guarding against the acquisition of unwarranted influence, whether sought or unsought, by the military-industrial complex. The potential for the disastrous rise of misplaced power exists and will persist. Your Honors, in this state, and in this country, but specifically in this state, we have a mental health industrial complex that presents or can present a danger to the citizens of this state. A mental health industrial complex that the courts of this state are necessarily complicit in because they serve as a gatekeeper. And I see that my time is up, but if I may be permitted just to finish, Your Honor. The courts of this state serve as a gatekeeper to a determination of incompetency for persons who are alleged to be in partial or full need of protection, supervision, and assistance because of a disability. There is a great potential for abuse of that. I would ask this court to be very diligent and to be very careful in denying the rights of the citizens of this state, their full rights under the law and under the statutes of the state of Tennessee. There are difficult issues presented in this case, and I thank the court on behalf of my client for its consideration.
Thanks. Thanks to the attorneys for your presentation. And this case has been submitted to this court at this time, so you should be receiving our opinion and ruling within a reasonable period of time.
Thank you.
Thank you. You may be excused.